SJC-11668, Commonwealth versus Jose Fernandez.
Okay, Attorney Rocio.
Good morning, Chief Justice Bud, members of the Supreme Judicial Court. My name is Jim Rocio. I'm appearing on behalf of Jose Fernandez in this particular case. I'd like to acknowledge that there are friends and family of Mr. Fernandez who may be in the courtroom here today or are watching it online, and so I wanted to acknowledge that fact. I would begin by suggesting that the question that we suggest this case poses is this: can law enforcement investigations of a drug dealing operation and a murder actually be conducted in a manner that is so fast and loose as to be found to be unlawful or unconstitutional? We contend that the answer to that question is yes, and that this case demonstrates that. I'm going to focus in particular on the secret recordings that were perhaps the most compelling part of the Commonwealth's case. These are the 4 days of recordings that were made by the agent, Alexis Cruz, in the House of Correction when he was incarcerated with the defendant Jose Fernandez.
I understand why you are focusing on whether or not it's organized crime that's involved, and it seems like, although it was hard to pin down a bit, some of your discovery arguments relate to the Section 99 issue. But the first issue, it seems to me, is that they don't need a warrant here. They don't need a Section 99 warrant here if there's organized crime. It's a one-party consent through a police officer. So there's not even a need for a warrant. And so if there's no need for a warrant, then if the warrant didn't include anything about the South Carolina dancers, I'm having a hard time having your argument separate the warrant from the organized crime argument.
Justice Lowy, I agree with exactly what you're saying there. And in fact, this was initially suggested to be a blood warrant, but it's not a blood warrant because Commonwealth v. Blood doesn't apply unless it's a home setting. And this obviously, even though it might have been Mr. Fernandez's home, he was incarcerated at the time, and we conceded that the blood warrant requirement wasn't there. And the burden to establish that the exception of 272.99 applies. The designated offense, there's no question about that. It's the murder that occurred in May of 2009. But in connection with organized crime is what is required. And the burden to establish that is on the Commonwealth. And what did they proffer in this case? Nothing other than a 10-page affidavit that was submitted on November 17, 2010 by Trooper Giassi. That's all that the Commonwealth put forth. And if I could talk to that and point out...
Before you do that, how do you distinguish Mitchell, right? The exact same issue was dealt with in Mitchell, right? What's different about this case than Mitchell?
Well, there's actually quite a bit of differences, but the biggest difference, Your Honor, that I'd point out is that in Mitchell, there was an evidentiary hearing at the trial court level before Mitchell came up to this court. And so the Commonwealth had the opportunity to make its case that the exception of 272.99 applies. They had the same opportunity here in Fernandez. They didn't avail themselves of that opportunity. That's perhaps the biggest difference between the two and a way to distinguish the two. We'll concede for the sake of, we understand what this court announced in Mitchell, saying that there was organized crime and it met the requirements there. So if you look at Trooper Giassi's affidavit, and if I may, I'll talk about what it's missing. There's a gap of nearly 14 months as he details his investigation.
But as you know, the DA's offices and AG's office very often will seek a blood warrant even when they don't need one with a Section 99. However, there was no affidavit needed, so there was no warrant needed. And in Mitchell, Chief Justice Gantz said, well, this is organized crime related to the drugs, and even if there was a personal nature to it, not his words, but the drug dealers needed sort of an image of credibility, so they couldn't let this situation with the Supreme Gang lie.
Right. I'll make 2 points, if I may, Your Honor. First of all, Chief Justice Gantz also said in Mitchell that the genesis of the dispute, the reason for the original dispute, was unknown. It was not known in the Mitchell case. In this case, it's clearly understood the genesis of the dispute that ultimately resulted in the tragic killing of Mr. Pina. It was a dispute about between Mitchell and Pina having to do with dancing girls that stemmed down in South Carolina and was brought up to Taunton. That's what this case was all about. It had nothing to do with organized crime, and the key time to look at, Your Honor, is May of 2009. We will concede, for the sake of this presentation, that based on Trooper Giassi's affidavit in November 17th, and I know the court is going to look at that carefully, you can actually track how he describes the results of his investigation to support his contention that the exception of 272.99 applies. And you can track it right on through up to paragraph 15 of it. It's everything about the murder itself, the subsequent investigation, examining witnesses and so forth. Absolutely not a scintilla of evidence or any comment whatsoever about an underlying drug conspiracy or ongoing drug operation. And then from paragraph 15 to paragraph 16 of that affidavit, that's it, pages 95 to 105 of the appendix. At page 100, you see paragraph 15, on Wednesday, June 10th, 2009, he's talking about his investigation stemming from the murder. Nothing at all about any drug connections.
So
and then
let me ask this question and tell me what's wrong about this, the premise of my question. So what the affidavit says is not dispositive. There was no affidavit needed. What the issue is whether or not there's evidence of organized crime. And the Commonwealth is going to say that the South Carolina dancers business augments the tie to organized crime, doesn't detract from it.
There was indicia of organized crime from June, July to August of 2010, based in part upon the investigation that was done by Trooper Baker of the drug offenses. Trooper Giassi, and it's quite obvious when you look at their, compare and contrast their respective affidavits, what Giassi was doing here. And it was basically incorporating the results of Baker's investigation into the drug. And that's perfectly okay for troopers working together, solving a crime and so forth, but we contend in this case they went too far. And I'll speak to that. I'd like to underscore the importance here. You look at Trooper Giassi's affidavit was all that the Commonwealth presented to the trial court to support their position that the exception of 272.99 applies.
That's the answer to my question. That's the evidence they presented. As to that, you just answered my question, because you're saying that the only thing the judge had to determine whether or not there was organized crime was the affidavit.
Exactly. That's all the Commonwealth did. And the motion should have been allowed at that point, absent anything further. The Commonwealth had the opportunity to do it. They did do so in the Mitchell case, and of course that's after the fact, and hindsight is always 20/20. But in this case, it wasn't there, and the motion should have been allowed. And
what's the answer to Justice Kafka's question, though, about why is this different from Mitchell? Can't we just take judicial notice of that case?
Yes, I mean, that's absolutely controlling law. And I'm not suggesting that this court should revisit the arguments in Mitchell that what was going on here was organized crime or not. will concede that, based on what we see in Trooper Giassi's affidavit, from August 2010 on, there's an indication that there's an organized crime component going on involving drugs. There's nothing before then. So it's a 14-month gap going back to the important period, which is in May of 2009. That's the time we got to look at. What was going on in May of 2009? Nothing regarding, at least on the record that the judge had available to him, nothing suggesting that there was competing drug cartels or anything of that nature whatsoever. So we contend that that the 272.99 was indeed violated. The exception did not apply in this case for the reasons we suggest, and that would be our statutory argument. I do want to talk about our contention that Article 12 bears some scrutiny in this case, and that has to do with the notion of inexplicably intertwined concept as an exception to the Sixth Amendment right to counsel, which under most circumstances is offense-specific. That's conceded. But there is this exception that has been recognized in Massachusetts. It was recognized in the Rainwater case in 1997. It was acknowledged in the Murphy case in 2005. I believe that's the correct year. But we are urging the court to revisit that notion of inextricably intertwined to see if it does have application as a matter of Article 12 here in Massachusetts. Other states are doing it, have done it, and in fact, I
saw your letter that there were 3 states that have. Should we assume that there's 47 that haven't, or that they just haven't reached the issue, or somewhere in between?
Well, I'd answer that very quickly by, no, you shouldn't make that assumption. But I will again concede the point that in the wake of the Supreme Court's opinion in Texas v. Cobb, that put sounded the brakes, if you would, to application of that exception, which was recognized before. In fact, the Jewel v. Indiana case that I cited is very instructive in many respects, talking about this principle of inextricably intertwined. If I may just quote from the Jewel case, I know it's another state jurisdiction, but it does have bearing here because the inextricably intertwined concept before 2001, when the Supreme Court decided Texas v. Cobb, inextricably intertwined was recognized in several federal court cases, federal jurisdictions, and in a number of state jurisdictions. Texas v. Cobb in 2001 comes in, puts the brakes on it in some respects, but in the wake of that, we are now seeing not a groundswell, not a rush and so forth, but gradually more and more recognition of this exception to the Sixth Amendment jurisprudence as a matter of state constitutional law. And if I may be permitted, just to quote from the Jewel case, when a defendant is represented by a lawyer for a particular offense, this is what the Indiana Supreme Court wrote, when a defendant is represented by a lawyer for a particular offense, do the police violate his right to counsel if they approach him about a different offense? Under the Sixth Amendment, the answer is no. I mean, this was in 2011. Obviously, that's 10 years after Texas v. Cobb. That under the broader protections of Article 1, Section 13 of the Indiana Constitution, the right to counsel is violated only where the different offense is inextricably intertwined with the charge in which counsel is already representing the defendant. The Jewel opinion, by the way, is very informative. It's very interesting because what the Supreme Court of Indiana did in the Jewel case is actually track the history, recall the history of that inextricably intertwined exception to Sixth Amendment jurisprudence at the time. And they note, for example, is to be viewed in two different capacities. One is inextricably intertwined, where the facts are similar or they're related. The facts of both cases are related. That's one way. But the other one, they say, another one that is characterized is labeled the circumvention of the Sixth Amendment right. And they say that exception applies when the government or state breaches its affirmative obligation not to act in a manner that circumvents and thereby dilutes the protection afforded by the right of counsel. That, we respectfully suggest, is exactly what has happened here. Based on an examination of the efforts by Troopers Giossi and Baker to work together. And so if I may, let me just, if I may, point out some of the reasons why we say that it does apply in this case, if I may, and then I'd like to conclude with a few remarks about the prejudice aspects of it, and then unless there's any other questions from the court. But speaking to why that exception does apply in this case, here are some of the things that we can look at. It's established now that in both investigations, we have the same case investigation number being used, whether it's the drug or the murder. So clearly they're working together. Nothing wrong with that unless it goes too far. I would invite the court to pay particular attention to the two affidavits. Giossi's, November 17th, 2010, found at pages 95 to 105 of our appendix, and then the Commonwealth submitted Baker's affidavit from, I believe, June of 2010, and that's it. I'm going by memory now. I believe it's pages 57 to 99 of the Commonwealth's appendix. And that's very interesting to compare and contrast the two. And you really get a sense of the extent to which Giossi all of a sudden starts to incorporate everything that Baker was doing at that point. The fact is that the murder investigation up to that point apparently had dried up. They had to do something to make the connection. Other factors, if I may. At pages 277 to 281 of the appendix, there's meeting notes of Trooper Giossi, beginning of November 2010, when they're going to sit down with Cruz and his lawyer and work out their deal. Who attends that meeting? Cruz's lawyer, representative from the district attorney's office, Trooper Giossi, and Trooper Baker. I think it's significant to note that where this all came from, it was a dispute that began between Mitchell and Pena in South Carolina, two men who knew each other. They were friends growing up. And that was that reference to that is not included at all in anything that Giossi or Baker put forth. The details of exactly how this went was represented by the prosecutor attorney at the time of trial. The prosecutor at the time of trial, he told the court what this case was all about. And it was nothing about turf protection or anything of that sort, at least in May of 2009, which is the important time to consider here. If this was in August of 2010, perhaps a different case, but it wasn't. The drug charges themselves were eventually dismissed. I think I can see my time is running short, and I just say that the Commonwealth continues to assert a work product privilege. I think we can draw from that a conclusion that there's other materials that we haven't seen yet that may support the claim we're making. I'd ask you to consider that as well. As far as prejudice, if I may, the testimony from Cruz was clearly the most compelling part of the Commonwealth's case. And I would invite the court to pay attention to as I'm certain you will, to the transcript in volume 11 and then into the beginning of volume 12, in which the prosecutor presenting that evidence does so in a way that really incurred the real anger of the trial court judge, the way the prosecutor was doing. You can draw your own conclusions by reading it, but it's pretty compelling when you read the transcript.
Was there a foundation about that they'd talked very often and that he understood from previous conversations with the defendant what the words would mean?
Conspicuous by its absence was anything like that, Justice Lowy, and that was noted by the trial court. When you read the transcript, you'll see that. On the second day, the trial court judge was obvious. He was very upset by what had happened. And he told the prosecutor, this is what could have been done to avoid this. But that's like trying to put the genie back in the bottle. The jury had already heard the damage the day before. They already heard in effect, Cruz ended up attributing to Fernandes a confession to this crime. And the trial court judge saw that and was really, you could tell he was really upset, so I call that together.
So it's not really the cases that you cite about requirements of an interpreter that's really your argument. Your argument is that there was no foundation for Cruz to be able to testify what the defendant meant, and that's what had Judge McDonald so upset.
Yes, but I do think the case we cite, Soto, I believe, is the case on the translation. I think that does have some bearing. And the trial court judge himself, when he was talking about this, said that, if I may just finish that question, and that this was like translating a foreign language, or words to that effect, that was in there. So unless there's any further questions, I'll rest on my brief, and thank you very much.
Thank you. Okay, Attorney Lee.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. I'd like to begin with my error in post-conviction discovery. I'm sorry, I'm getting upset. 3 years after I completed the discovery, the appellate administrative assistant in my office found a misfiled file in the appeals file. And then when I went to make sure that all those documents were cumulative of what I had provided in post-conviction discovery, I determined that the IT department had consolidated the digital files, which meant I had to cross-reference all the documents from that digital file with the post-conviction discovery. And in doing so, the vast volume of thousands of pages had indeed been given. I discovered a mistake of my own. I worked on it for like 2 weeks, night and day and weekends, and I discovered my own discovery error. Immediately called counsel, tearfully apologized, as I apologized to this court and to the defendant. And counsel was very gracious, but of course, his primary concern must be the rights of his client, the defendant, as are they. They are also mine. When I make a mistake, I own it, tell everybody, and try to fix it, and try to make sure that there's no prejudice. The defendant has supplied a supplemental appendix. I agreed to the inclusion of the documents that he deemed appropriate from this October 2022 discovery. I have cross-referenced those documents. He claims he didn't get grand jury transcripts. The grand jury transcripts he referenced were provided in 2019, as was that list. It's the list that I provided in 2019, had handwritten notes on it. There's a pretrial document saying all grand jury materials were provided. There's a pretrial document saying all GIASI documents were provided. If you compare his discussion of McCone at Supplemental Appendix 15 to 23, specifically pages 20 to 21 and 22, with the defendant's own record appendix at pages 101 to 102 and 104, you'll see that they are identical. So the McCone stuff is not new. All the wiretap materials were provided. My post-conviction discovery letter is in my record appendix. The notes of the grand jury, the actual grand jury transcript was provided. You can see it In the Commonwealth's appendix at 388 to 452, that was made part of the record in the post-conviction proceedings. The pages at 25 to 36, you'll see in my letter at the end of my record appendix, that one at CA 489, that one was provided in post-conviction discovery. I just wanted him to know what was in the misfiled file. He has included Kathleen Sully's Corey, it's a docket. If you look at transcript 7, pages 56 to 60, she actually testifies about her criminal charges that docket relates to. So that's not a surprise. That was pretrial discovery. And the last part is Crystal Fernandes. It's her. Crystal Fernandes was not a witness in the case. She's the person who held guns. She's Thomas Jeffrey's girlfriend. She held guns. Marcus Mitchell went to get a gun from her home. That's her relationship to this case. They put in her probation matters. Her name is throughout the pretrial discovery reports. You'll see throughout it's mentioned at trial. If a person wants the probation records about a witness in the case or a potential witness in the case, they get that from the probation department under Rule 14A1A4. And so I would suggest that those materials, I don't want to undercut my error. I made a mistake trying to fix it, and I'm very apologetic about it. But these materials, I stand by my statement that these materials that he has provided in his record appendix are cumulative of what was provided in post-conviction discovery in 2019, and they don't raise any concern when compared with the trial record in this case, and therefore I suggest no remedy is required for it. However, if this court disagrees, the remedy is an evidentiary hearing, which is what the defendant asked for in his Rule 30 motion and did not get.
Now, what about the affidavit of trial counsel as far as getting the materials,
Right.
recognizing that he did get the materials, but that he ended up not auditing the discovery letters? How does that fit into everything?
So Attorney Bradel was the trial attorney, very experienced, and he was actually on this case even prior to the indictment. And the record shows that some of the materials were being provided before indictment with the May 2nd, 2011 letter. So the defendant presented Attorney Bradel's first affidavit, which said, I didn't get these 4 discs. They're DVD interviews, including Alexis Cruz, which is, I'm not going to suggest anything about Alexis Cruz is not crucial to the case. It's crucial to the case. He's right about transcript 11 and transcript 12 with Alexis Cruz's testimony. So he's basically a star witness. He's the person who recorded the defendant on the blood warrants. So the Attorney Bradel is saying, I didn't get these. So we provide proof. Here are the cover letters. Here are the reports that show you had notice of the DVD interviews. Attorney Bradel is an excellent attorney. And then he files a supplemental affidavit saying, I had the cover letters in the trial file, in my trial file, but I don't think I got those DVDs. This record shows, one, that the trial file he gave to counsel on appeal is not complete. We don't have anything from Attorney Bradel saying that he searched for these materials after being noticed, how he kept his materials at his office, whether he has lost anything or potentially lost anything from his file. And another important point that shows Attorney Bradel's second affidavit also cannot be credited, not because of a lack of truth, but because of a lack of memory, which he acknowledges in his affidavit. But he said he was unable to cross-examine Alexis Cruz about his arrest by Trooper Fredette, particularly about marijuana and use without authority. And he says there was a missing report, and it's in the defendant's record appendix at 343 to 347. Not only did the defendant, Attorney Bradel, cross-examine Cruz on this incident at transcript 1257 to 62, Attorney Bradel called the trooper at transcript 13, 165 to 177, and asked him about the marijuana usage. And then when the Commonwealth was cross-examining him, this is at transcript 13, pages 183 to 184, he actually references that report to refresh his recollection. It is impossible that Attorney Bradel didn't have a report by Trooper Fredette. It is impossible that he didn't have these discs and didn't notice it. And there's a pretrial affidavit from Attorney Bradel saying that he had reviewed the whole record. His post-conviction affidavits, with respect to Mr. Bradel, his post-conviction affidavits show a lack of memory.
Well, yeah, I mean, he's saying as best as I can recall. He's not, he has that prefatory comment in there.
But even when his claims are disproven, he still says, I must not have gotten it. I didn't audit the record. He's saying, I didn't audit the record 9 years ago, but 9 years ago, he was saying, I looked at all the records. I would suggest that that's not a sufficient affidavit to warrant an evidentiary
But
hearing.
you can't blame him for that. If he says he looked at all the records, he means he looked at all the records he had.
Well, but he definitely had notice. I mean, he admits his trial file has those cover letters.
I know, but I'm just saying it's not necessarily inconsistent, because when he says I looked at all the records, what he's saying is I looked at all the records I had.
And what is missing is, what did he do when he found those cover letters? Did he go back and look for anything else? And we don't have anything in his affidavit about that. What we have is continually making claims. So he says he didn't get the Gomes interviews, but he had those, we know he had those DVDs. Those are on the list. He wrote, the Commonwealth has been able to show pretrial discovery with one exception, which is the letter Alexis Cruz wrote to his attorney a few weeks before trial. First of all, I'd like to say that letter that we provide in post-conviction discovery shows Commonwealth's good faith. That was not part of the grand jury materials, which was the subject of the post-conviction order. We were providing trial notes and as much information as we could to assist counsel and to be as open with our file as possible for the post-conviction discovery. That letter shows that Alexis Cruz wanted more. He's that star witness, so he wanted more, even though it was coming up to the trial date and he'd been provided substantial information. And my suggestion to the court is that if you look at that letter, it doesn't say the Commonwealth's giving him anything else. It says that he wants more, and there was a grueling cross-examination on all the benefits he had been provided and how he had breached the agreement and still got all those benefits. And then even after trial, he was expecting that his criminal matters would still be disposed of as part of the agreement. So the jury was well aware that he still wanted more, regardless of whether he abided by the agreement, regardless of whether he had finished testifying. He still wanted more, and that's really all that letter says. So I don't have a pretrial discovery letter to show that that letter was given, but the content of it shows that that letter was given, and I would suggest the content of the trial transcript shows that Attorney Bradel was fully apprised of all of this information.
How about the 2011 report about Cruz having been shot in 2011?
So that's the mid-trial disclosure.
Yeah,
So
right.
the Commonwealth's position is it was never going to offer that evidence. It's not exculpatory because a person cannot be impeached with being victim of a crime. We conceded that it was unrelated to this crime. The defendant was about to cross-examine, I believe, Alexis Cruz when it came up, either that he was just being called as a witness. The prosecutor wanted to alert Attorney Bradel to it. Unlike everything else at trial, where Attorney Bradel was fully aware of everything else, at this point he's like, this is the first time hearing of it. I have my cross-examination already, and now he said they're throwing a bomb into it. The trial judge heard his objection and said, this is all staying out. It's all on the Commonwealth's burden. Nothing comes in. If something about that comes in, there's going to be a mistrial, and Attorney Bradel can ask whatever questions he wants. Attorney Bradel said, thank you. So the defense claims, well, if we had known about that beforehand, we could have proved it was unrelated to this case. The Commonwealth conceded it was unrelated to this case and did not offer it. And two, maybe they could have connected it up to show some kind of exculpatory evidence. However, 8 years passed from the time of the mid-trial disclosure until the motion for new trial, and nothing has been done on how to connect it up. And so I would point to the Fossa case and the Brito case. The defendant can't just speculate that something good would have come of it in a motion for new trial. He's supposed to do something with that information and show why that was relevant to the investigation. And so, but the Commonwealth's position at trial was that that was not disclosed because it was irrelevant. I would like to note that the defendant is now claiming that there's a fraud on the court, citing CPCS versus AGO, and I would like to very strongly suggest to the court that that has no basis. It's about the South Carolina dispute. The prosecutor actually discussed the whole South Carolina dispute without any claim from Attorney Bradel that this was new material in the pretrial hearing before the judge ever made the findings on the pretrial motion to suppress based on nexus. And I would suggest to the court that shows, one, Bradel knew all about it, and two, that the prosecutor was being very open about it, and three, that the issue of the the omission of the South Carolina dispute from the wiretap documents, the affidavits, was all known to Bradel. He did not raise it and did not preserve it, and that was raised in the post-conviction claim. I think in terms of nexus, this case falls squarely within Mitchell. It's the same exact incident. It's the same exact description. Mitchell is the co-defendant. Mitchell occurred after the trial in this case, I think, definitely after the trial in this case. But, so the defendant didn't have the benefit of it. But had the defendant raised the claim about the omission of South Carolina and exotic dancers at so-called gentlemen's clubs, that would have failed and should fail under Mitchell, because Mitchell is right. It's right, literally right on point.
Well, their argument is that the difference is that in Mitchell, there was an evidentiary hearing, and that here, there was no evidentiary hearing, and if you look at the Commonwealth theory of the case, it's not a theory of the case that this is a drug turf dispute.
So in Mitchell, if you look at the description of the affidavits in the Mitchell case, the same as in this case, I think you look at the four corners of the warrant to determine whether there's probable cause and nexus. And you can see the records that were provided. They're in the Commonwealth's record appendix at 57 to 102 and 115 to 117. Those are the documents that were provided to the pretrial motion judge, and those show nexus. They have Team Supreme. They're organized. They work together. They deal drugs. There's escalating violence, and I would suggest that's sufficient for nexus, and you don't need an evidentiary hearing for that. In terms of the evidentiary hearing, what you'd need is the outside materials on South Carolina dispute, and here we have the trial where the South Carolina dispute is fully versed throughout. The defendant tries to note that the prosecutor said that this wasn't a gang case. He is taking the prosecutor's statements out of context. What the prosecutor was saying is, we're not going to use gang evidence. What we want to use is that they're Team Supreme. They have the tattoos showing death before dishonor, and the motive evidence, as well as the access to guns. I would like to just jump to the rainwater issue. This is one party consent. Alexis Cruz was in jail at the same time as Fernandes, the defendant. The defendant was in custody on bail on drug charges, not murder charges. The murder was not charged yet.
Yeah, but the inextricably intertwined point, the troopers, I mean, they know Cruz is going to not only, they know he's going to start with the guns. I mean, he wants to make sure that it comes out that they're not his.
Right, he's mad because it was Mitchell's gun in the car. First, I'd like to make a note. I said that he was arrested, Cruz was arrested in October. Cruz was arrested in July, which I make note of later on when I'm talking about Fredette's case. I'm sorry about that. So he's arrested in July on Mitchell's gun, and Fernandes is arrested in August on the drug charge. The drug charge postdates the murder. That's like summer of 2010. The murder is May 2009. And then in October 2022, that's when Cruz agrees to turn state's evidence with the help of his attorney, and the defendant has provided the report of that meeting in his record appendix. And so I would suggest to the court that those are not, the murder and the drug charges are not inextricably intertwined. They're different in place and time. They might have... Which,
by the way, might back into appellant's other comment, which is the 2010's the drugs. The May 2009 shooting is before the drugs, so that the drug turf war is not the organized crime support for the Section 99. Right,
so I'd again look at I would look at the affidavit. That's getting back to the nexus thing. I rely on the affidavit provided in the Commonwealth's record appendix in comparison with Mitchell, which said that that was sufficient. And I would suggest that that is correct. In terms of the inextricably intertwined, I I admit a little bit of confusion. My understanding was rainwater uses the inextricably intertwined analysis, which is more protective than the Sixth Amendment under Texas v. Cobb, and that's the position I've taken in my brief, and I apologize if I'm confused on that, but I don't think the defendant's asking you to adopt new law on inextricably intertwined. I thought that was already the law here in Massachusetts, and the cases he provided are similar. They have a similar analysis, and so I would suggest you have an uncharged murder that predates the charged crime of drug dealing, and therefore the charged crime of drug dealing is not inextricably intertwined with the murder, and it also doesn't violate the Sixth Amendment under Texas v. Cobb, because that actually requires an analysis of lesser included using double jeopardy analysis. So if they're not lesser includeds under federal law, then you can go talk to person in custody, even if you're a Commonwealth agent, government agent. And so I would suggest that that was done appropriately, and even though we might not have needed a blood warrant, we went and got one. We did it with judicial approval as well. And it also doesn't violate the Fourth Amendment because it's one-party consent, and because
So going back to Justice Kafka's initial question, is Mitchell just dispositive?
I think Mitchell's dispositive. I can't tell them apart based on the record that we have and the record that's in Mitchell. They look exactly the same, and I think that's why the defendant was asking, well, maybe you should overrule Mitchell, and I would suggest to the court that overruling Mitchell would does not mean that he gets the benefit of Mitchell, because he did not push this South Carolina omission at pretrial, but he did preserve the nexus issue at pretrial.
Sorry, are you done? I'd like to go backwards, just so I understand the discovery mix-up. I just want you to summarize for me a couple of things. One, what was missing and why it's cumulative, and secondly, how we deal with that, given that the trial judge on his doesn't have the benefit of any of that, right? So just walk me through that, because that's...
What was missing is that letter from Cruz to his attorney that occurred 3 weeks before trial, and I would suggest that it's cumulative of the cross-examination of Alexis Cruz.
Okay, do this slowly, okay, just because this is... So what's missing is what? Sorry, the letter?
The letter from Alexis Cruz to his attorney, it's dated February 2013. It's a few weeks before the trial. The whole copy of it is in the defendant's brief. And I would suggest if you compare that with the cross-examination of Alexis Cruz, then my position is that it's cumulative. The jury knew he got a lot of stuff, he wanted more stuff, and he expected to get more stuff after trial. And the more stuff after trial that the jury heard was that he wanted his charges reduced, which is not reduced, disposed of favorably, which is worth better than money.
And anything else?
The only other thing is the mid-trial disclosure, which I've already gone over.
Yeah, but I'd like you to go over that one more time.
Sure. So the mid-trial disclosure is a second shooting of Alexis Cruz. The Commonwealth's position is that that was not related to this case, and the judge excluded every reference to it after the defendant's objection, to which the defendant...
Unless the defendant wanted to use it.
The defendant could ask whatever questions he wanted.
Unless the defendant wanted to use it.
Right. So that gets us to how do we know that that's not prejudicial? And so the defendant
But that's what the defendant's saying is, well, yeah, but I didn't have time to figure out if I could use it.
Not at trial, but after the fact, he had 8 years to connect it up, as he's required to do under FOSSA, which is an appeals court case, but well-reasoned, and it's comparable to Brito, which is not the same exact scenario, but the showing the defendant must make in a Rule 30 motion. So he has 8 or 9 years to say, why was the second shooting of Alexis Cruz relevant to my case? And we concede that it's unrelated, and it didn't come in at trial, so there's no problem there. So he would have to show something to connect it up, and he's done nothing after the disclosure of it to show that that was prejudicial to him after he got the remedy that he thanked the judge for.
So those are the only two things we need to worry about? Those are the only two missing things that come up? Because
I don't want to speak for my brother. From the Commonwealth's perspective, those are the only two things I've tried to explain why the stuff in his supplemental appendix is duplicative.
His reply brief, and I haven't gone through this whole record, his reply brief says seems to describe more stuff, right?
Right, and that's what I went over in the beginning of my argument. all the things in his supplemental appendix to his reply brief. So I stand by my position that those are cumulative. I apologize greatly for making the error, but the only things we can really call our own are mistakes, I guess. So I really hope that this court finds, as I have found, that there is no unfair prejudice to the defendant in this case. And I thank you for hearing me out, and I would ask you to affirm the convictions in this case, except for the ones that are duplicative that we conceded.
Thank you.
Thank you.
Thank you.